May please your lordship and your ladyship. My name is Mosongo. I appear for the 7th interested party, Kitocha Shiria, alongside Margaret Awor.
Please, your lordship, my name is Daniel Manso. I do appear for 3rd interested party.
My lords and my lady, if it may please the court, my name is Mudhomi Thienkolu for the 2nd interested party, and I appear together with Mr. Moses Kipkogei, Mr. Kennedy Meli, Mr. Boniface Mwereru, Mr. Steve Ogola, and Mr. Kenson Mutethia.
May it please the court. I will introduce counsel appearing for the respondents in the interests of time. My name is Githu Muigai. I'm instructed by Christopher Marwa, who is instructed by the Honorable the Attorney General. For the National Assembly, 2nd and 9th respondent is represented by my learned colleagues, Eric Gumbo, Paul Nyamodi, Moses Kipkogei, Alex Baya, and Elias Ouma. For the Senate and the Speaker of the Senate, the 3rd and 4th respondents, my learned friend, Professor Tom Ojenda, appears with Mr. Mokele Moni and Ms. Thanji. Dr. Thionkolu has already introduced himself, and I will not repeat that. For the 9th respondent, Mr. Michael Mushemi, and Ms. Gafira is holding brief for Mr. Kamodo for the 10th respondents. Ms. Joy Anami and Hassan Noor are instructed by the 16th respondent, IEBC. Those are the appearances. Sorry, I would like to amend the representation of the Speaker of the National Assembly to include Mr. Sore, S-O-R-E-H, Sore. Those are the appearances. One.
Judgment. My name is Harrison Kinyanjui. With your very kind indulgence, I do appear for a petitioner in petition E586 of 2024. And my lord, my lady, we filed an application in the Court of Appeal to arrest the delivery of this judgment. This was after the 4th of June. The same petition was not heard when you had directed and ordered it be heard on this, on the 7th of June, 7th of May. You had ordered, directed, be heard on the 4th. On that 4th, it was not even listed for a mention. It was listed for a hearing. Because your initial direction was that that petition should be heard as a standalone petition, so that then the decision that will be made in the consolidated petition, together with that, would now be the judgment of the court, because the Honorable Chief Justice had appointed your lordships and my lady as the bench in that petition and as a bench in this petition. Now, when on the 4th of June, the said hearing aborted, we filed an urgent application before the Court of Appeal. CO application number 291, E291 of 2026. I also wrote an email letter to the Chief Justice as the head of the judiciary to bring into her attention the precipitate injury and ruinous violation of the petitioner's right to be heard before you render yourselves in this petition. Accordingly, the Court of Appeal certified that application as urgent. This morning, I served on everyone, including all the parties that are before you now. That application relates to the Court of Appeal's jurisdiction under Article 165(3), and therefore, in deference to the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest the delivery of a judgment, so that then a judgment can be rendered that is encompassing that petition and the consolidated petitions. I had, in deference to Section 20, subsection 1H of the High Court Administration and Organization Act, informed the Deputy Registrar of this court that application pertains to the arrest of the delivery of your judgment. And the Honorable Deputy Registrar then alerted me, asked me if I had communicated that to everybody, and I did. And therefore, in deference to the equivalent of the least pendants rule, that application being alive before the Court of Appeal, that this Honorable Court then defers the delivery of the judgment. My lords, as I close, my lady, the right to be heard, being enshrined in Article 25C of the Constitution, is non-abrogable. It cannot be abridged. Way of disposing of any matter.
I don't think we are for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business.
You have
the Court of
answered
Appeal.
me. You have answered me.
May I finish, Judge?
You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond, just for good order? My lords and my lady, we do not in the least, I do not in the least want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June 2026. And so that my learned friends can respond. On the 7th of May, before you, learned Senior Counsel Professor Agido Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinyanjui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purpose of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal. And therefore, it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my Lord, I associate myself with petitions made by senior counsel. The fact that that file is not before you, my Lord, form the basis upon which this judgment can be deferred. And most importantly, my Lord, counsel having not given sufficient reasons, my Lord, for adjournment, my Lord, or arresting the judgment, my Lord, I think the legitimate expectations of the 4th to the 49th petitioners, my Lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my Lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ongoya. Yes.
Thank you.
My Lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my Lord, you could deliver judgment as it had been agreed before. I thank you, my Lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all.
My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Ongoya, and in the absence of a clear order and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
So for this, I will fully associate with the submissions that have been given by this court is full and everyone is waiting for this judgment.
Thank you.
My lords and my lady, if it pleases you, speaking on behalf of the 9th petitioner, I will wish to fully associate myself with the submissions made by my senior and my teacher, Senior Counsel Zebedee Ongoya. My lord, over and above that, perhaps it will benefit the court to notice that we have only but been served with the application.
I'm alive to the fact that this court is on a constitutional duty. My lord, the date for hearing was... I served that application from the Court of Appeal, difference to the Court of Appeal's directions. And we cannot sit here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar. There is nothing out of the ordinary from these consolidated petitions. Learned Counsel, really, having looked at my petition, never having answered in that petition, Muthomi Thiankolu never filed a single sheet of paper in that petition, and he is appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordship's in you saw the peculiarity of that petition. Your Lordship, I'm not going to go. So that Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My Lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my lords, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that Your Lordship,
Mr. Kinanjui,
yes,
we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this honorable court, I very believe this honorable court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.
Mr. Kinyanjui, this is the brief ruling on that matter. First of all, we want to note for record that the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, you yourself sought to be deconsolidated in that matter. And we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not misrepresent facts. Listen, I'm making a ruling on this matter. The matter is not before us. The Court of Appeal has had or has cited that matter. If they wanted to stop us, we would drop our pens. Give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's ruling. And for record, and this is the last comment we are making on this issue, your matter is coming for a mention on 18th of June, 2026. Parties before the court, are you ready to proceed?
Thank you very much, Your Lordship.
I take it that parties are now ready to take judgment in the constitutional petition number E65 of 2024, consolidated with Nairobi petition number E550 of 2024, Nairobi petition number 570 of 2024, number E572 of 2024, Kerugoya petition number E013 of 2024, Kerugoya petition number E014 of 2024, Kerugoya petition number E015 of 2024, Nairobi petition number E522 of 2024, Nairobi petition E506 of 2024, Nairobi petition E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, Nairobi petition number E541 of 2024, E567 of 2024, E576 of 2024, E586 of 2024, and E598 of 2024 between Honorable His Excellency Rigathi Gachagua petitioners Rigathi Gachagua, Thomas Kimotho Maingi, John Jerry Maina, David Munyi Madenge, Peter Gichobi Kamotho, Grace Mudhomi Mwangi, Clement Mchiri Murioki, Edwin Munene Karioki, Sharia Mtani na Shadrack Wambui, Father Eddie Waiguru, Anthony Muithaga, Victor Gatia, Assunta Wangui Mwiruri, Christine Mukami Njuguna, Peter Kimani Kioira, Alice Wamuhu Mbugwa, Mwangi Anyeki Mbugwa wa Mumbi, Kigo Kahari, Priscilla Wambui Gitari, Muchiri Ngatia, Maria Njeri, Eric Warui Mwaniki, Brian Hunja, Sarah Hubi, Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Samuel Ngari, I accept, Council, that the parties are known. We can move ahead, and others versus the respondents. Speaker of National Assembly of Kenya, Speaker Senate, Senate of Kenya, Honorable Attorney General, and several others. This is the judgment.
For the sake of clarity, I believe the lead file in terms of the directions that this Honorable Court gave is E565.
Yes.
That is not quite what I heard.
Yeah, that is the lead file.
That is the position.
Yes.
Thank you.
This is the judgment. We have a 350 page judgment. We'll try as much as possible to read it. Introduction and background. In the general election of 9th of August 2022, the first petitioner, hereinafter referred to as His Excellency Gachagua, was elected as the Deputy President of the Republic of Kenya alongside His Excellency William Ruto, whom we refer to as President. Their election was upheld by the Supreme Court, paving the way 18th of September 2022, beginning what was expected to be Article 145 sub-Article 1 and Article 148 sub-Article, however, was cut short following the successful impeachment of His Excellency Gachagua. The process leading to his removal when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter refers The motion, referred to as impeachment motion, cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows. Ground 1, gross violation of Article 10, sub-Article 2A, B, and C, Article 27, sub-Article 4, Article 73, sub-Article 1A, and 2B, Article 75, sub-Article 1C, and Article 129, sub-Article 2 of the Constitution, and Article 147, sub-Article 1, as read with Article 131, sub-Article 2, C, and D of the Constitution. Ground 2, gross violation of Article 147, sub-Article 1, and 152, sub-Article 1 of the Constitution by undermining and the Cabinet and effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6, sub-Article 2, Article 10, sub-Article 2A, Article 174, Article 186, sub-Article 1, Article 189, sub-Article 1, and the 4th schedule to the Constitution by undermining devolution. 4, gross violation of Article 160, sub-Article 1 of the Constitution on the institutional and decisional independence of judges. Article 5, Ground 5, gross violation of Article 3, sub-Article 1 and Article 148, sub-Article 5A of the Constitution, and fidelity to the oath of office and allegiance. Ground 6, serious reasons to believe that Rigathi Gachagua had committed crimes under Sections 13, subsection 1A and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that Rigathi Gachagua has committed crimes under Section 45, 46, 47, and 48 of the Anti-Corruption and Economic Crimes Act and Section 2, 3, 4, and 7 of the Proceeds of Crime and Money and Anti-Money Laundering Act. Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Ground 9, gross misconduct under Article 150, sub-Article 1B of the Constitution by publicly attacking and undermining the work of the National Security Intelligence Service and its officers. Ground 10, gross misconduct or insubordination by openly or publicly insubordinating the President, who is the head of state and government. Ground 11, gross misconduct by persistently bullying state and public officers. The impeachment motion was formally initiated before the second respondent, that is the National Assembly. In response, several constitutional petitions were filed in the High Court, challenging both the legality and constitutionality of the National Assembly's proceedings. These petitions, consolidated with Nairobi petitions, which I had mentioned earlier, were consolidated and are collectively referred to as the Cohort 1 petitions, with petition number E522 of 2024 designated as the lead file. 56, that was Cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Kerugoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were ruling of 31st of October 2024, paving way for earlier stated. Thereafter, the pleadings were amended and cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' cohort 2 petitions. Summary of pleadings. Submissions. His Excellency Gachagua is the first petitioner. His case is as follows. Further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024. Speaking to the deficiencies in the process before, Excellency Gachagua deposed that the impeachment motion lacked the particular required under Article 145, Sub-Article 1 and A. He took issue with the lack of credibility in respect to the Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He stated that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest, as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the Current Hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at Current Hospital with severe chest pain. He deposed that given his age and underlying risk factors, including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly announced the process into an election rather than an 149 sub-article 1. For these reasons, a declaration that the respondents have contravened the provisions of 18 sub-article 1, Articles 10 and Article 118 by initiating a process leading to the removal from office by impeaching the petitioner without first putting in place adequate legislative effective public participation. In particular, the Senate's decision was from public engagement. 2, a declaration due issue lacks the particularization and specificity sub Article 1 of the Constitution and Standing Order 64(1)A, and is thus incapable of invoking the jurisdiction of both the under Articles 145 and Article 150. 3, on 18th of October 2024 by the National Assembly purporting conditions of Articles 145 and 150 and the communication October 2024 by the Clerk of the National Assembly to the Clerk of the Senate of the National Assembly on a special motion on the removal from Excellency Gachagua, Deputy President of the Republic of Kenya, close process on a process that is inconsistent and are thus both void and invalid. For the purposes of impeachment of the President or Deputy public participation must be undertaken in all the 200 Kenya, the diaspora constituency, and the 1,004 where the presidential election takes place. 5th, of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the time for the National Assembly to facilitate any meaningful and participation during the process of impeachment of the Republic of Kenya. Thus, the standing order is unconstitutional of abridging the time for public participation. 6, the proceedings before whole House, the Senate of Kenya, under Article 145 of the Constitution of Kenya, are not bound to 10 days, as would be if a special committee sub-Article 4A. He also sought a declaration that the petitioner's right to fair administrative action, right to fair hearing under Article 50 sub-Article 1 of on account of the petitioner being denied an adjournment, violating his right to appear in person before the Senate of the case. He also sought a declaration in their evaluation of the impeachment proceedings before them, each of the specified grounds, and determine if they collectively or of the Constitution warranting voting to uphold the impeachment. The resolution of 8th of October 2024 in the National Assembly charges that of the Senate passed on 17. The threshold for impeachment set out under Article 150 as read with hence the same be and are hereby set aside to remove into this honorable court and quash of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024 respectively, resolving to remove from office by impeachment His Excellency Deputy President, Republic of Kenya. At the 9th prayer, the petitioner sought an order of certiorari to bring up a resolution of the Senate of Kenya made on 17th of October 2024. His Excellency Rigathi Gachagua, EGH Deputy President, Republic of Kenya, Gazette Notice number 13-400. He also that a declaration does issue that the IEBC the involvement or approval of commissioners under Article 88 of the Constitution as read with Section 4 and Section 11A purported clearance as further, the overnight clearance violated Article 10 and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as and national administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for court's determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145, sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then lastly, what are the available reliefs? They collectively, the lawyers for His Excellency, the petitioner Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. he submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145, Council noted that the threat of gross misconduct and serious reasons prove reserved strictly for the gravest constitutional transgression. Council drew the support from the particulars we have given. Muya appointed to investigate the conduct of Justice Martin Muya. We have given citations to argue that grounds must be substantiated by intermediate standard higher than a balance of probabilities. Admitted that since impeachment directly interferes with the sovereign will of universal suffrage, courts could not abdicate their responsibility to a purely political immune process. It was his case consequences of removal brought the matter squarely with requiring it to interrogate whether Parliament met the standards. Senior Counsel Paul Mute submitted and the political question doctrine. He was emphatic that the system is an extraordinary constitutional remedy of last resort. Architecture from parliamentary systems where executive tenure relies. It was his case that the deputy president derives direct democracy through universal suffrage and cannot be removed due to or partisan convenience. In view of the democratic will, it was Senior Council's position that strict procedures and substantive safeguards that courts are. Learned Counsel drew support from the decision in Mike Song to restate that the threshold for removal could not be reduced. He further called to his aid the Court of Appeal decision of given citation to argue that judicial review of the mercy rather than offend the concept of separation of power. Respondent's invocation of the political question doctrine as such autonomous islands immune from accountability, and he maintained remains subordinate to the judiciary's review. Head Counsel Mr. Chiang Dudley submitted on jurisdiction to adjudicate. At the outset, he pointed out an case, simultaneously conceding the court's jurisdiction while it. He submitted that constitutional adjudication could not be implicated political institutions or carried political and that once allegations of procedural impropriety or rights cease to be purely political. Drawing on the United States versus Virginia, we've given citation, he argued improperly when it declines constitutionally when it arrogates jurisdiction it does not possess. It was imposes a mandatory obligation on the High Court whose constitutional violations are alleged as such, the judiciary would itself violate the Constitution. Politically sensitive questions. Mr. That separation of powers does not establish institutional immunity as Parliament acts within its boundaries. Citing the Supreme Court in the matter of Kenya National Commission on Human Rights, Council interpretation in such disputes must be transformative rather than mechanical. In the written submissions, this ground 8 of the charges, noting that it relied on code, a provision already declared unconstitutional general matter. On the right to a fair hearing, he maintained his inalienable right by proceeding in his contrary to Article 50, sub-Article 2F and Article 25. Support from Karaoke versus Attorney General that denying an adjournment impacting a citizen's constitutional rights. He further submitted that the rushed manner of the proceedings mirrored condemned in Olo versus Kisumu County as rendering the resulting decisions absolute. Submitting on public participation and institutional in Gachagua's case that both houses entirely failed the threshold. Mohammed and 6 others versus County Assembly of Wajir. Other cases which we have state that engagement must be substantive, one, and utilizes satisfactory mechanisms. In addition, His Excellency Gachagua, while drawing support from the decision independent electoral board, discredited the involvement of the IEBC. Requiring commission approval could not be lawfully discharged by the Secretary Commission. In their rejoinder submissions, the legal team illegality in plenary investigation. It was His Excellency lacked a lawful resolution to appoint a plenary. The word may in Article 145, sub-Article 3B, the committee is a mandatory obligation, relying on a set of authorities versus Registrar of Trademarks and another routinely interpret may as mandatory to effectuate legislative intent. Drafting history from the Guy and Bomas drafts to the Wako and case that it proved the framers' constitutional committee to investigate charges prior to any plenary. In conclusion, His Excellency Gachagua drew inspiration from the Duterte versus House of Representatives. We have given citation. It reiterates that impeachment processes remain to check grave abuses of discretion. Consequently, discretion as established in Imanyara and 2 others versus Attorney General for the constitutional violations to vindicate His Excellency Gachagua's right legislative infringements.
From the second petitioner's case, Maingi. Thomas Kimoto Maingi, the second petitioner, filed a petition dated 25th September 2024 The petitioner described himself as a former member of the intelligence service, NAS, and contended that his by statements allegedly made by His Excellency Gachagua concerning the conduct of NAS during the finance. He averred that, having served in the NAS for over 20 years, 2022, he was publicly associated with the intelligence service, and that the remarks by His Excellency Gachagua portrayed and responsible for the unrest witnessed during the protest. He asserted that the hostility, threats, and psychological distress for his home in Kirinyaga County and seek refuge in safety. Mr. Maingi further contended that the Attorney General constitutional duty as the principal legal advisor to government Gachagua appropriately regarding the provisions of Section and 26 of the National Security Intelligence Service Act related to NIS. Alleged violations 28, 29, and 47 of the Constitution amounted to discrimination, infringement of torture, and unfair administrative conduct. Consequently, that there be a declaration that the constitutional rights of under Articles 10, 27, 28, 29, and 47 of the Constitution respondents be that the first respondent be to the NIS members and staff for made on the 26th of June 2024. C, cost of the any other relief the court may deem. The second, file any written submissions. The Honorable Njeri Maina, the third petitioner in the constitution dated 2nd of October 2024. That was 2024 before the High Court at Kerugoya. She is in the National Assembly for Kirinyaga County. She stated that, and on behalf of the residents of Kirinyaga County and public discretion as and in public her petition also principally challenged the legality and procedural propriety of the impeachment proceedings. She contended that public participation process and attention to the impeachment motion was ineffective, inadequate, and unconstitutional owing to the short notice periods and in issue with the insufficient dissemination of information, the lack of proper facilitation of members of the public, and to comply with court orders directing constituency. She further asserted that the impeachment process violated Articles 145 and 150 of the Constitution and challenged the constitutional 64(2) of the National Assembly standing orders an unconstitutional 7-day timeline for disposal of undermining meaningful public participation. Also questioned the legality of the Senate's decision to things in plenary instead of through a special committee and 3 B of the Constitution, urging that impeachment charges could only lawfully be undertaken by a select committee of the challenge the legality of the National Assembly as constitutional two-thirds gender principle under Articles 27 and 261 of the Constitution, and full entertaining an impeachment motion. As such, Honorable Mayor, a declaration that the modalities put in place by of the public participation forums that were scheduled for the 4th October 2020 regarding the special motion fell below the threshold of proper, effective, and meaningful under Article 10 of the Constitution. B, a declaration that the modalities in respect of the public participation forums held 5th of October 2024, as ordered by this honorable, were in disregard of the court's orders and fell below the on meaningful public participation as envisaged under Article 10. Declaration that the impeachment process, as again as the first interest, the first and the second respondents in their in view participation forums held on the 4th and 5th October 2024 have a proper, effective, and meaningful public participation as envisaged under Article 10 of unconstitutional and therefore void. D, appointment of a select committee by the Senate under Article 145(3) discretionary in the impeachment of a president or deputy president of the Constitution. A declaration that any proceedings interested party taken by the second and fourth the select committee of Senate under of the Constitution are unconstitutional and void. Respondent is not legally constituted in light of the mandatory under 261 of the Constitution on the two-thirds gender. The first respondent, as currently constituted, cannot entertain and motion for the removal of the first stated party by respondents. Any other order or orders that this court may deem. The third petitioner's submissions. Positions by filing written submissions dated 9th of January 2026, which she further orally highlighted in court. Determination. 1. Whether the public participation exercise conducted 4th of October 2024 met the constitutional threshold 18 of the Constitution. B. Pamphlets deployed by the National Assembly violated constitutional requirements. 3. Whether the Senate violated Article 118 by not Senate stage. 4. Whether the Senate violated Article 1 by failing to appoint a special committee of 11 members. Standing Order 64-2 prescribing time is constitutional. 6. Whether safety on fair hearing protections. And 7. Whether conducted by impartial officers as required by Article 50. Honorable Maina submitted that on the 3rd of October, Justice Mongo, a judge of the High Court sitting at Karugui, participation be undertaken at the constituency levels so as to engage and offer their representations that were never appealed, stayed, varied or on the respondents absolutely, speaking to the obligation to obey admitted that such obedience is foundational to the rule of law as in Law Society of Kenya and 3 others versus Inspector General of Police and 4 others 24 KEHC. That this obligation extended even to cases where the person affected it should be irregular or void, as was held in Refrigerator Limited versus Gulab Chand Popat, application number Nairobi 1339 of 1990. Proper compliance required reasonable notice and not the physical accessibility at constituency level with open each of the 290 constituencies, facilitation of engagement, information, language diversity, disability as the primary mode, including oral and interactive. Learned Council further submitted that the orders were not obeyed. 200,000 participants countrywide who made 4% of the Kenyan population turned up for the exercise. The notice published on a Saturday whose contents were offices without addresses and times. She also organized, no facilitation was provided, and that CDF offices were absent. Honorable Maina submitted that she became aware of the purport and that none of her counterparts within the Kirinyaga County. She further submitted that even the citizens who visited the constituency and no officials of staff were in sight. It was the Assembly faced a binary choice of obeying the Constitution or preserve standing, which provided for 7 days deadline. They chose describes as contempt addressed. That a legislative outcome in defiance of a binding court order cannot stand governed by the rule of law as discussed by Lord Denning in United Africa Company Limited, reported in 1961, 3 or 1169, where the learned judge held that, I quote, then it is in law anality. You cannot put something, it will collapse, end of quote. Honorable Maina also took issue with fraud as the National Assembly deployed as standardized or constitutional allegations into binary tick box questions. Whether they supported impeachment on each ground without being supplied with explanatory memoranda, and His Excellency Gachagua's Supreme Court and British American Tobacco BAT versus Cabinet, which we'll hereinafter be referring to as the BAT case. Full participation to include clarity of the subject matter, the public to understand structures, processes that are clear and simple from public, commitment to the process such that views and inclusive and effective representation. Transparency of the process and capacity to engage sensitization of the subject matter. Honorable Maina admitted that English-only mechanism systematically excluded rural persons with disabilities, the non-English speakers. She stated that there were no physical venues, the template or receiving oral views that were that there were only 10 pictures of people attached for attendance for the 5th October exercise, and that they were responses from 4th and 5th obscuring the impact of the court's orders. She identified that a procedural imperfection, but designed to manufacture numerical support for a predetermined and is therefore constitutionally void. It was her further imposes an independent obligation on each House of Parliament to facilitate business, that the Senate is not a subordinate appendage. Was held in Speaker of Senate versus Attorney General, reported in 2013. She stated that the Senate is nominative under Article 145(7) as it performs a of the highest constitutional order. She held that the Senate could not constitutionally rely on the National Assembly where that process was conducted in defiance of court order. Was aware of these defects as they were documented and judicially acknowledged. Counsel submitted Speaker of the Senate 2025 reported. This court held that Senate must satisfy itself that public participation and satisfaction requires inquiry, assessment. The Senate undertook none. That the Senate conducted no notices were issued, no invitation were extended, no hearings were, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145 of the Constitution provides that the Senate may appoint a special of its members to investigate the matter. On that sublimation was a grant of power, not a license to. Once the Senate had elected to proceed under Article 145, architecture prescribed, which includes a special committee. Under Article 145, Sub-Article 6, report is triggered only if a special committee reports substantiated and absent a committee report, a determination was not opened. She also stated that the committee was structured investigation, not political debate, receiving, interrogating, and a reasoned report and insulating investigation of volatility or plenary politics. That article guaranteed the deputy president the right to appeal for the special committee, and by bypassing the committee, the Senate guaranteed to the deputy president, thus violating the Learned Counsel submitted that standing orders confirmed this distinction. The deputy president impeachment provided for a special committee alternative. That standing order 80 of the governor's impeachment procedure expressly provides two alternatives, that is, it was then posited that where the drafters intended to permit, they could have said so, and that the omission of the deputy respected. Learned Counsel 3B of the County Governments Act, which provides that the Senate may appoint a special committee and that the courts, including Wambora, this confers discretion and the Senate has lawful that those decisions underscore the opposite. Where law expressly provides alternatives, discretion exists, but only one investigative pathway. The discretion does not other. She submitted that by proceeding to plenary in a special committee, the Senate acted without jurisdiction by passing the investigative stage and extinguished a guaranteed hearing right. She also constitutionally distinct phases into a single political exercise, therefore unconstitutional, null and void ab initio. It was a further submission that Standing Order 64-2 null infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. 4 of the Constitution will provide that any law that is inconsistent void to the extent of the inconsistency. She placed Rigathi versus Speaker of the National Assembly, reported in 2024. Orders cannot override the Constitution nor substitute the Constitution as expounded by the courts. In that light, Parliament's it being argued that Standing Order 64-2 structurally compliance. She submitted that where standing order made adherence to possible, such a standing order is itself unconstitutional. Standing Order 64-2 embodied a deliberate parliamentary political expediency over constitutional safeguards by prescribing rigid that once an impeachment motion gained initial to conclusion before public sentiment, courts could intervene meaningfully or before they affected effective defense. Counsel argued that this was precisely the event, since impeachment is not a mere vote of no confidence. Constitutional process carrying grave consequences. Should declare Standing Order 64-2 unconstitutional, null and void, lines incompatible with constitutional requirements, and that terms is tainted with illegality from inception. That His Excellency Gachagua was accorded a fair hearing. Honorable Maina submitted with chest pains on the eve of the Senate proceedings. Despite incapacity, the Senate proceeded with the hearing and voted their of the fair hearing rule, Audi alterem partem. Counsel further argued that the 12 days between were constitutionally inadequate, given that Article 50 sabbatical sufficient time and facilities to prepare defense. His Excellency Gachagua and complex a constitutional of the Constitution, abuse of office and corruption for which 12 as the Supreme Court affirmed in Sonko case, proceedings attract the protections of fair hearing is denied, the process collapses. On the issue of termination, Learned Counsel submitted that both Speakers of Parliament impeachment motion were constitutionally required to maintain acted contrary. It was argued that they assumed the and proponents of the impeachment, thereby transforming into advocates neutral arbiters. In particular, Speaker was said to have participated in public statements and the proceedings. Counsel emphasized that the test for bias is a minded observer would conclude that there exists a submitted that the speaker's public statements are this threshold. Where the presiding officer is biased, fundamentally unfair, and the failure of the speaker tainted the process. For the but to grant the relief sought in her petition. Next is this. In the consolidated petitions, that is Honorable David Munya, Peter Gechobi Kamoto, Grace Modoni Mwangi, Edwin Munene Kariku jointly filed a petition dated before the High Court of Kenya at Kerugoya. They and leaders drawn from various constituencies within Kirinyaga instituted the petition both in their personal capacities on behalf of their respective constituencies and in the way petitioners herein challenged the constitutionality, legality, and procedural appropriation taken against His Excellency Gachagua, together with the subsequent nomination of Honorable Kindiki relating to His Excellency Kindiki nominee. They contended that conducted by the National Assembly on the 4th and 5th October and unconstitutional. In particular, they pointed to the issuance of sensitization, inaccessible venues, absence of parliament officials at designated constituency sites, closure, and the overall failure by both the National Assembly and the Senate to facilitate meaningful Articles 10 and 118 of the Constitution. The petitioners unlawfully conducted impeachment proceedings in plenary instead of 53B of the Constitution, and that the rash timelines imposed under National Assembly standing orders were unconstitutional as they curtailed effective public participation hearing rights. They also alleged that the Gachagua's constitutional allegations they also violated His Excellency's rights under Article 25C and 50 of adjourned proceedings on the 17th of October 2024 medical emergency, thereby denying him an adequate opportunity. The petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contravened sections 3 and 6 of the Public Appointments Parliamentary of the laws of Kenya for want of adequate notice and public participation. The following prayers. A declaration that the appointment of second interested party herein as Deputy President of the Republic is invalid, null and void. B, a declaration that the national plan is required to undertake its own distinct public participation as envisaged under Articles 10 and 118 of the Constitution president or a deputy president. C, a declaration that the Senate as a distinct on its own distinct proper participation as envisaged under Articles 10 and 118 of the Constitution, to a resolution from the National Assembly to impeach a president or a deputy president. As scheduled by the first and the second respondent on 4th of October, not a proper and effective and meaningful public participation as a declaration that the extended public participation respondents on 5th October 2024 was issued by the High Court sitting at Kerugoya in constitutional petition number E4, Honorable Jane Jerry Maina versus the National Assembly and 4 others, a meaningful public participation as envisaged under Article 10 of the Constitution. That the impeachment process as against the first interested party was undertaken by the first and second respondents, proper, ineffective, and meaningful public participation held on the 4th and 5th October for void. G, a declaration that the take any public participation at all in regard to the against the first interested party renders the whole Senate impeachment process void. H, to bring up into this honorable court and quash the last and the third respondents met on the 8th of October 2024, respectively, resolving to remove the of Kenya by impeachment, that there exists no vacancy in the office of the deputy president to nominate anyone to fill such vacancy, and that any such nomination and void. J, any other order or order just and expedient in the circumstances. K, cost of. Next is the 4th to 8th. In their submissions led by counsel, Mr. George Sakimpa, the 4th to 8th petitioners identified examination. A, whether the impeachment process complied with Articles 10 Constitution, whether the public participation conducted by the National Assembly and the Senate meaningful, adequate, effective, and lawful. A, whether a standing order 64(2) of the is unconstitutional for imposing rigid timelines that under. And D, whether Article 145 and applicable investigation into impeachment charges be conducted exclusively by a special committee sitting in plenary. They submitted that Article 10, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance, that the impeachment process was conducted unlimited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct public participation, and that this was not a formality. They contended that the National Assembly gave the hours to consider complex, voluminous impeachment charges, firstly, in adequate time frame, that no explanatory notes or responses from the Deputy President were provided. Kirinyaga, designated venues were in. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the Constitution. And they relied on authorities in Kenya, 3 others, reported in 2025 KL Assembly, and another versus Okoit and 55 others. Civil appeal number E003 of 2023. This is the decision of the Court of Appeal. They also relied on Doctors for Life and in Legal Advice Center, and 2 others of Mombasa. On the unconstitutionality of the National Learned Counsel argued that the provision imposes rigid, make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights. And Article 24 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64 as the matter in which the Senate proceedings were to be 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive and between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, sub-article 4, sub-article 5, and sub-article 6 refer exclusively to the special committee mention of plenary investigation or under expresso ineus est exclusio ulterior all other modes of investigation. The petitioners further that the special committee of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary and the judgment into a single political process in sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the appeal held that the removal of a governor which mirrors Article 1 sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, sub-article 1 guarantees expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was putting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the label foundation of any removal process. In support, they cited Gachagua versus Speaker of the National Assembly and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. That Standing Order 64.2 is unconstitutional. A declaration the special committee and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack filed the petition dated 18th of October 2024. David, sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protect the rule of law, constitutionalism, accountability, and good governance, and the legal validity of the impeachment proceedings leading to the removal of His Excellency Gachagua from office as Deputy President, and further question the legality of the intended nomination and approval of Rigathi as his replacement. It contended that 19th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, Sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment, informed that His Excellency Gachagua had fallen ill and had been admitted, him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fairness and natural justice by proceeding with in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. That although the Constitution contemplated an expeditious impeachment process, not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sharia that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President Kindiki as Deputy President under Article 149 of the Constitution. Nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of constitutional qualifications of any nominee to the office of the Deputy President. So argued that His Excellency Kindiki's nomination contravened 137 of the Constitution on the Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein to which is under Articles 25, 50, 27, 47, 145 were grossly violated respondent on the 17th of October 2024 for declining on the Senate sitting deliberating on his removal from. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of that it was done in gross violation of Articles 25, 57 and 145.5 of the Constitution was unconstitutional to the extent of its unconstitutionality and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, does hereby issue to bring to its court, to this court, the via Gazette notice dated 17th of indicating the removal from office of the Deputy President from the office by way of the order of certiorari, does hereby issue to bring to this court the of the Republic of Kenya nominating His Excellency Kithure as Deputy President of the Republic of Kenya for the purpose of quashing the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2) Constitution. F, be pleased to make a declaration that the appointment of the Deputy President by the President of removal of the interested party from office pursuant to Article 149 together with Article 82 and 88 of the Constitution to give the IEBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G, a declaration be made that that the approval of or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88. Costs of the petition be provided, interest on one above, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the led by Counsel Shadrach Wamoy, the ninth respondent identified three principal issues for court's determination. A, whether the nomination of a Deputy President can be legally of a fully constituted Articles 82 and 88 of the Constitution. B, whether the Senate's refusal to grant His Excellency Gachagua an adjournment due to documented illness during the impeachment proceedings constituted a breach and natural justice under Articles 25C, 47 and 50 of the Constitution, and C, whether the nomination of Honorable Kindiki is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was, and that the Senate rushed the proceedings and unnecessary and adjourned to allow him to recuperate. The Senate proceeded with ex parte proceedings, leading to his removal from office in his absence, which violated Articles 27 and 145(5). The organization relied on the Supreme Court decision in by T2 and 4 others, reported in 2014, which affirmed that fair hearing incorporates the auli alteram partem principle to the Court of Appeal in Judicial Service Commission versus Mutapa and another, reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative. Senate has no prescribed time limitation for and the rushing was unjustified. That Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 and 137(1)(b), 37, and that Article 137(1)(b) provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 2 include a Cabinet Secretary. It submitted that at the time of his nomination, April 2024, His Excellency Kindiki was serving as the Cabinet Secretary for Interior, and therefore he did not eligibility criteria, rendering his nomination null and void ab initio. It was the organization's time in October 2024. The IBC was not fully constituted commissioners, as the previous commissioners had resigned or retired. Establishes a constitutional architecture requiring a lawful electoral and nomination processes, and that the Supreme opinion number 4 of 2024, reported in 2025, and must be drawn between administrative continuity by the Secretariat and vested in the Commission as a collegial, that the exercise of constitutional functions reserved for Article 88, sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted commission with the requisite quorum. It was further submitted that in the absence of incapable from undertaking its mandated electoral process of a deputy president nominee, the second highest constitutional office, constitutional responsibility than delimitation of boundaries and the with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, sub-Article 3b in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors endorsement enunciated in Jacqueline Okuta and another versus AG, High Court, and that it further submitted that the unconstitutional mandate cannot be shielded from judicial scrutiny. Constitution versus National Assembly of Kenya and two others, 2013. In the end, the petitioner prayed accordingly allowed. I now proceed to the 10th to 41st petitioners. That's you. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily. They filed the petition dated the 17th of October 2024. On the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent Deputy President of Kenya, stating that the to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. Instead, they said that instead they are Standing Orders 64 and 65 for the National Assembly and Standing Orders 78 and 79 for the Senate without necessary modifications. The President does not have the same powers, prestige, or President. The petitioners aver that this failure rendered the entire null and void ab initio and violated the 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducement, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people. The August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region voted for that joint mandate. The petitioners also highlighted and incorporated arguments Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. That the President accepted foreign gifts valued at approximately Kenya shillings 240 million in hire and fuel costs for a state visit to the exceeding the legal threshold permitted for such gifts. The President entered into a secretive treaty with the Kenya as a non-NATO ally without tabling their Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of parliament to bypass oversight, as well as intentions to artificially control the majority party coalition. Accused the president of using state violence to criminalize, otherwise read the Generation X, as the July 2023 protests against oppressive tax living, and that he distributed state appointments along. Additionally, H.E. Gachagua was faulted for publicly dividing shareholders and non-shareholders in quotes based on H.E. President Ruto is accused of spending hundreds of funds to conduct avoidable by-elections caused by senators to the cabinet. The petitioners further argue agreement binds H.E. President Ruto to nominate from the Gikoyo, Embu, or Meru communities to Deputy President. They sought a declaration to nominate a new Deputy President was subject to certification that the nominee meets qualifications under Articles 99 and stating that the 14-day and 60-day timelines in Article 140 public participation across all 90 constituencies. Petitioners asked the court to declare the nomination and approval of new Deputy President as unlawful, null, and void. The following reliefs from this court. A declaration be issued to declare that the first petitioner was impeached by the Senate under a procedure that violated Articles 27 Article 2 of the Constitution. 2. A declaration be issued and respondents have violated the rights of the petitioners and Central Kenya region by failing to govern together in accordance secured during the presidential election held on the 9th of August. A declaration be issued to declare that the first petitioner was under the respective standing orders of the National Assembly and Article 150 sub-Article 2 of the Constitution. Be issued to declare that the impeachment of the first petitioner on account of the violation of Articles 25 read together with Articles 144, 145. 5. A declaration be issued to declare that the 14th respondents have conspired and schemed from office through impeachment in violation of Article and 38 of the Constitution. 6. A declare that the second respondent violated Articles 110 and 50 of the Constitution in passing a resolution on 8th October the second respondent from office. 7. An order of certiorari be issued to quash the resolution of the second 2024 to approve the motion of impeachment of the October 2024 by the 9th respondent. To declare that the 6th respondent's power under Article to nominate a person to occupy the office of the Deputy President by the Independent Electoral and Boundaries Commission and 137 of the Constitution. 9. Declare that the 14 days period prescribed under Article 149 nominate a person to occupy the office of Deputy President with Articles 10, 38, 99, and 130. 10. A declaration be issued to declare that the 6th under Article 149(1) of the Constitution on the President's nomination to fill the vacancy in the office is to ensure compliance with the requirement of 290 constituencies in accordance with Article 7, 38, 118, and 136. 11. That by dint of Articles 1, 38 of the Constitution, the first respondent is bound by the dated the 5th of April 2022 to nominate either of the Gikuyu, Embu, and Meru communities to of the Deputy President occasioned by the impeachment of the self. A declaration be issued to declare nation and of approval therefore by the National Kindiki, the second interested party herein, as Deputy and void ab initio. 13. Issue an order of certiorari to quash the nomination by the National Kindiki as a Deputy President via Gazette notice issue of the Kenya Gazette dated 18th October 2024. Declaration be issued to declare that by dint of Article 138, 91, and 132, the citizens of Kenya from the Gikuyu, Embu, and Meru community by the results of the presidential election held on 9 to have one of them to occupy the office during the tenure of the first respondent as the president of. A declaration be issued to declare that standing orders number 6, the National Assembly standing orders violates Article 150. 16. An order of certiorari 64 and 65 of the National Assembly standing that they apply to the Deputy President. 17. To declare the standing orders number 78 and 70 adopted on the 16th of June 2024 violates Article 152. 14. An order of certiorari be issued to quash standing 79 of the Senate as adopted on 16th June that they apply to the Deputy President. 19. Issued to compel the National Assembly and the Senate, that is the second, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20. that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, cost of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between HE President Ruto and HE Gachagua. They submitted that the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached by the National Assembly and the Senate under a procedure that violated Article 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of ground 1. D, whether the standing orders number 64 and 65 and standing orders number 78 and 79 of the Senate was impeached violate Article 152 of the whether the Senate's failure to establish a special committee 6 of the Constitution rendered the removal of H.E. Gachagua. Issue F, whether H.E. Gachagua was subject to the Senate. G, whether the 1st to 11th respondents schemed to remove H.E. Gachagua from office in violation of 27 and 38 of the Constitution. Of impeachment for political settlements. The petitioners completely manufactured by a political fallout rather than grounds under Article 151B of the Constitution. Fundamentally unconstitutional for the executive and parliament of impeachment as an administrative tool to resolve and vendetta. They submitted that the impeachment procedure Assembly and the Senate were weaponized and conducted in substantive and procedural provisions guaranteed under the standing orders of both chambers. They specifically maintained governing the process, that is, standing orders 5 of the National Assembly and standing orders 78 and 79. Article 150, Sub-Article 2 of the Constitution and must be. The petitioners equally submitted that H.E. President replacement under Article 149 was strictly sub BBC under Articles 99 and 137 and 16-day constitutional windows under Article designed to guarantee rigorous public participation in constituencies. The rushed nomination and approval was unlawful. It was null and void ab initio. Directly violated the political rights of the petitioners A fortiori, the petitioners argued that this court quash the impeachment to halt an ongoing executive an imperial presidency in Kenya, and they want subservient and sycophantic to the executive, acting parliaments of the late 1980s, which present existential threat, to Kenya's constitution. Stated the prayers that sought to declare the impeachment null persecution that violated Articles 25 to the Constitution and orders of certiorari quashing the national 2024 resolution approving the impeachment motion and Gazette Notice 13401 Kindiki as Deputy President. They also sought to Order 64 and 65 and Senate Standing Order 9 to the extent that they apply to the removal of a deputy compel both chambers of parliament to permit a legally compliant, constitutionally envisaged deputy president under Article 150 sub-article. Has relied on various local authorities, including the as well as Jirongo versus Limited. They also relied on foreign authorities, including the Law Society of Alberta, Republic R versus Campbell, R versus you will find in the judgment, all from the Supreme Court of. Further reliance was placed on books, articles, speeches, interview statement by on the Senate floor as per the Hansard of 9th October 2020 statement by H.E. Gachagua on Inoro TV. Prayed that their petition be allowed as prayed. Third petitioner's case, Mr. Morara Omo, 9th October 2024, before the High Court of Kenya, supporting affidavit sworn on the same date in his capacity as citizen and patriot, acting in defense of constitutional democratic governance. The petition challenged the constitution proceedings commenced against H.E. Gachagua. He contended that the impeachment process was effective, unconstitutional, and undertaken in violation expressed during the 2022 general election. The alleged violations of Article 110, 48, 50, 73, 54, 118, 145, petition that the impeachment motion tabled by the Honorable preceded by adequate public participation and that the legislatures in support of the motion failed to consult their supporting the impeachment process. He further alleged that the in support of the impeachment motion was tainted, influence, intimidation, and forgery of signatures. He contended that the subsequent public participation exercise in October 2024 was merely cosmetic and in public participation because it was hurried, poorly publicized, and conducted through only one center. He He also complained that the public participation forms against H.E. Gachagua and omitted his response to him unheard and violating the principles of fairness. He also alleged bias and conflict of interest and Deputy Speaker of the National Assembly. He contended that publicly supported the impeachment process before the motion in Parliament, thereby compromising their constitution as neutral and impartial arbiters during the proceeding. The impeachment motion was politically motivated and arose within the UDA party, yet the parties involved internal party dispute resolution mechanisms under the for initiating impeachment proceedings. Said no comprehensive statutory framework governing the collection of signatures for impeachment motions, thereby deficient and constitutionally uncertain. Sought the following orders. A declaration that the third respondent does not meet the threshold set out in as read with Article 150 of the Constitution. The impeachment of Geoffrey Rigathi Gachagua was unconstitutional. Declaration that the Speaker and Deputy Speaker of the National Assembly were disqualified themselves from the impeachment process. D. Motion violated the interested parties' rights. 33, 38, 47, 48, 50 of the Constitution of Kenya 2010. E. A declaration the interested party was tabled in a manner that violates 94 and 118 of the Constitution, as no party acted by Honorable Mutuse Ekomas Mwe, who appended their signatures prior to moving the impeachment motion. A declaration that the impeachment motion, which was in the United Democratic Alliance Party, was tabled exhaustion of internal remedies contrary to the exhaustion 59 of the Constitution of Kenya. G. A declaration legislation operationalizing the provisions of Article of Kenya. There is no legislative and administrative framework. The DP was anchored. And H. That each party. In his submissions, Mr. Omoke focused on two: whether the impeachment of H.E. Gachagua was unconstitutional, lack of legislation to operationalize Article 150 of the impeachment. He wholly adopted dated 7th October 2025, submitting the impeachment transcends him and must be evaluated with a view to the rule of law. He maintained that public participation as the mover of the motion and the 291 MPs in support of the impeachment motion did not conduct any public constituencies before signing, contrary to Articles 118 of the Constitution. That public participation questions arose on 1st October 2024 about would be conducted. The Speaker directed that 2024. The advertisement appeared on 2nd, which Mr. Omoke submitted was not a genuine public participation from the outset, that the by the National Assembly contained only the allegations against, conveniently left out his response denying the public way the grossness of the alleged violations. He submitted for only 9 hours from 8 a.m. to 5 p.m., which was a Friday, meaning most Kenyans could not. That venues were changed on the eve of the exercise, changed from IFAD Hall to Talent Academy, from KICC to Bomas of Kenya. His constituency, only about 2,000 people attended, and registered voters, that there was no proper coordination as utter pandemonium akin to the. He contended that in some areas, especially in Mount Kenya, forms were faulty. There were incidents of pre-filled forms. The filled forms was torched in Nyeri County. Extended the exercise to the following day, but no proper notification was made, and MP. He added that in some constituencies like West Mugirang, the constituency office, and that the other county and one center per constituency is too deficient. Should have been conducted at least at each polling station. Mr. Omoke submitted that the National Assembly neither nor considered the feedback collected and the entire hoodwink innocent Kenyans. He accused Deputy Sholei of being biased in that on 23rd September, speaking at a function in Uasin Gishu County, she swore to speak and put the Deputy President on notice, stating nitakupeleka nyumbani. In brackets, I will personally take. Also hinted at some of the grounds of impeachment before the motion was. He further argued that Speaker Moses Masika Wetangula on 29th, while attending a church function at Wamonyo Catholic Church in Machakos, took a stand on the impeachment motion before it was tabled. Description in Mark 9:38-50, he stated, being a part of the body that leads to sin should be cut off. Violated Articles 47, 50, and 150, and that neither the Speaker nor the Deputy Speaker should have preceded. Mr. Omoke submitted that the for impeachment as the standard, as a measure, is a and that grudges and squabbles cannot. He contended that extraneous grounds were introduced October 2024, as it was alleged that H.E. Honorable Florence Jematea Sergon, the as a harlot, that Honorable P. Suba North referred to conversations he had with her providing any proof. Honorable Patrick Macau also made references to conversations without providing. On the vote that 281 MPs supported, opposed, and there was one absentee, MPs abdicated their obligation to weigh the grounds standard of proof set by the Supreme Court versus IEBC and 3 others. The addition of 7,176,100 who voted for the joint ticket on 9th August 2020 held by the Supreme Court, and that the motion was an agreement of the majority with that of a few. It is admission that no statutory legislation exists on the President and Deputy President from start to completion. Framework exists on the collection of signatures in support of a motion. Therefore, there is no framework upon which the Deputy President was anchored. He and others, that is the Attorney General, this court was persuaded, who was a petitioner therein, that the lack of legislation and on the conduct of referenda initiated. He submitted that the same principle applies here and that to the fairness of the process, that the court ought to issue a structural edict requiring enactment. He submitted that areas include initiation of the impeachment process, how Parliament, particularly public participation, and the actual replacement of an impeached deputy president, provision for an impeached president or deputy president is of conservatory orders to preserve the rights of the impeached, hearing of petitions arising from an impeachment. Reason why the court could not have maintained the conservatory H.E. Gachagua and had the petitions within a week. Discharge of the orders, followed by an immediate declaration swearing in of a new deputy president, left a mind efficacy of Article 50 of the Constitution. For a declaration that the impeachment of H.E. Gachagua and that a declaration that the personalizing Article 150 of the Constitution rendered the president flawed. The 8th petitioner's case. Obuli Namenya, Dennis Okumu, Simon Mushangi, and jointly filed the petition dated 30th September 2020, High Court of Kenya at Nairobi. They describe themselves as to constitutionalism, the rule of law, and that they also instituted the petition in the public post-impeachment of H.E. Gachagua as deputy president. As per their petition and the supporting affidavit, Namenya, the petitioners challenged the constitutionality on the basis that Parliament had failed to establish a proper governing public participation in impeachment processes 13 and 124 of the Constitution. The petition neither the National Assembly standing orders nor the Senate mechanisms, procedures, threshold, timelines, venues, or modalities for meaningful public participation proceedings, thereby rendering contemplated unconstitutional. They further argue that public participation is a constitutional prerequisite which ought to precede any asserted that the 7-day timelines prescribed understanding for disposal of impeachment proceedings were constitutional as they undermined effective public participation to fair administrative action and fair hearing 50 of the Constitution. Additionally, alleged that the impeachment process was political bias and lack of impartiality on the part of citing public pronouncements by parliamentary leaders motion. They advanced a historical argument president and deputy president in Kenya, contending that successive deputy historically been subjected to political hostility, dismissals, and frustration, which informed the constitutional design of 2010, requiring the president and deputy president to be elected jointly. In prayers, a declaration that the impeachment process of a deputy is in nature and that public participation forms a significant role in attaining the right to Article 50 of the Constitution. B, a declaration that avenue or means through which the people can exercise under Article 1 of the Constitution in determining created under the Constitution ought to be abolished. Mechanisms created under this Constitution ought to be otherwise, and that the lack of elaborate procedure or certain or conducted will ordinarily holds power and subsequently amount to a violation. C, a declaration that the Article 2 that clearly provides for participation, and Article 124 creates standing orders. Neither the National Assembly an act of parliament providing for the procedure on how the president or deputy president is to be undertaken. Standing Order 64 or 65, or the Senate Standing Order provided for the procedure governing element of public participation relating to the impeachment president. D, a declaration that the National Assembly 65 or the Senate Standing Order number 74, as they were never subjected to the mandatory public participation. E, a declaration that the must with certainty and clarity contemplated under Article 118 should be that must precede all other processes relating, connected, or of the Deputy President. F, a declaration that all Kenyans must be subjected to the principle of equality of the law, while Article 47 requires that a person an administrative process that is procedurally fair, expedited, reasonable, and lawful one's status in society, and that the related the same by commencing an impeachment process with illegalities. G, a declaration impeachment process is a fundamental infrastructure that of 50, and that the absence of the same will amount to violating, denying, threatening, or infringing the right to a fair trial during his impeachment. He is an important resource for any judicial or quasi contemplated under the Constitution, and that the 7 provided for understanding Order 64.2b of the National Assembly and the Senate Standing Order 73.1 amounts to trial in, and the same will amount to Article 50. I, a declaration that National Assembly Standing Orders and the Senate Standing Order number provide for the sufficient and adequate time for carrying out quantitative, meritorious, accurate, and secure the hearing and determination of the impeachment trial before into a fair, just, impartial, and judicious determination of the impeachment trial as contemplated under Article 47 and 50 of the Constitution. A declaration that for purposes of authenticating and verifying and taking part in the public participation, confirming all the like that of citizenship, the total number of participants, public participation ought to be undertaken by an impartial from Parliament. Looking at the 44th to 48th petitioners' submissions, led by learned counsel, the petitioners focused on the constitutional architecture of a deputy president, submitting that the process was because impeachment is a measure of last resort, and that the Senate failed to apply the mandatory modification 152, which requires that Articles 5 be applied in quote with necessary modifications. Mr. Ndegwa submitted that the proceedings violated 50, including the refusal to adjourn when the deputy president process was infected with bias, irrelevant considerations of the Standing Order 75-78, cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachagua's submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination: whether the impeachment of the deputy president met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms, whether the constitutional framework governing the impeachment of a deputy president under Article 150, Sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a president under Article 145, whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79, whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure, whether the impeachment process satisfied the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions, whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void, whether the impeachment process violated the Deputy President's right to equality and equal protection of the law under Article 27, whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law, whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations, whether the refusal to grant an adjournment upon the Deputy President falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense, whether the Senate misapplied Standing Order 78 by proceeding without affording procedural safeguards and by improperly treating the proceedings as time-bound, whether the impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, Subarticle 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Orders 75, 78, and 80, and the legal effect of such violations. Whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional. Whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional process is found to be procedurally and substantively defective. The Learned Counsel submitted that impeachment is not intended to be a mechanism for addressing alleged misconduct, but reserved for the clearest and most compelling case. No full avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, criminal prosecution, and administrative action. Impeachment. It was emphasized that Article 143 immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations in the first instance be addressed through ordinary legal processes. Parliament, however, and resorted to impeachment as a first recourse, which principles of proportionality, rationality, and legality. They further submitted that no evidence considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Attention to Article 152, which provides the 45 apply to the Deputy President with the necessary modification. Counsel argued that this phrase is not a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and express principle. Mr. Ndegwa submitted Senate Hansard is the Speaker recorded as guiding the House the necessity, the scope or content as the Senate proceeded as though Article 145 and in total without any modification. He stated that this failure is not merely procedural but a substantive and jurisdictional issue which renders unconstitutionally defective ab initio. The petitioner's requirement ensures that impeachment is not in mechanisms such as the courts, EACC, or it was their case that the failure to modify the procedural safeguards that would have arisen from a including consideration of alternative accountability mechanisms in procedure to ensure fairness and enhanced and proportionality of the impeachment. It was their submission that the office of Deputy President from the sovereign will of the people expressed at the ballot impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of the office holder and the electorate. That article has the right to elect leaders and to have them serve their only to lawful and constitutionally compliant failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Ndegwa submitted ill during the proceedings while actively engaged. This is not disputed and is recorded in the Senate Hansard. That the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 and facilities to prepare a defense, and Article right to be present when being tried, and Standing Order 80 on the right to be heard. That a hearing conducted in the absence of the principal defense participant due to verified illness, conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 2B to adjourn without violating, but the refusal was not dictated by lack of time to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exercise, and that proceeding with impeachment during illness to a procedural object rather than a rights-bearing. Stated that Article 48 on the access to justice, adjudicative processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment, and denial of an adjournment rendered access to justice. Also submitted that the test for bias is objective and whether a reasonable and informed observer would apprehend bias, acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. As the impeachment process as a whole, not in fragments, noting that the petitioners have demonstrated cumulative defects, including failure to apply the modification rule under 152, absence of impartiality and presence of irrelevant and extraneous considerations, violation, misconstruction of the constitutional and procedural framework, and breach of Standing Orders 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 162 vests the High Court with jurisdiction to determine whether constitutional authority is inconsistent with or Constitution. They contended that this court is not being with parliamentary politics, but is being invited to perform its core constitutional function and fundamental rights, and where Parliament acts within the court differs, but where it acts outside those intervene, not as an intruder, but as a as such, the petitioners urged the court was not a measure of last resort when ordinary legal bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the issue that the refusal to adjourn during illness violated 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no legal effect. They then be allowed in entirety.
From the 51st petitioner's case, Mwangi, the 51st petitioner, in the consolidated 26th of September 2024, before the High Court of Kenya, public-spirited Kenyan citizen and Mwangi contended that the impeachment process was politically motivated. She relied on public Honorable Didmas Baraza and Honorable Gladys Posholey in September 2024, indicating that the impeachment had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with Gachagua. Ms. Mwangi asserted that the allegations leveled Gachagua were vague, unsupported by evidence, and lacking in specificity and peculiarity, requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process was designed to settle political scores rather than a lawful constitutional process related the national values and principles under Article 10, equality and protection of human rights. She maintained that adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence. 5C, 35, 47, and 50 of the Constitution for the following orders. A declaration that within the purview of 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment is entitled to be informed substantially with peculiarity and specificity, and supported with evidence of the impeachment proceedings by the National Assembly and Senate. respondents, restraining them from a collection of signatures. Impeach His Excellency Rigathi Gachagua, lodging any motion and the Deputy President of the Republic of Kenya, an order of compensation enshrined and provided for, and of Kenya made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. Petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the Emmanuel Elijah Otieno was the petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024 together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 contended that impeachment process undertaken by the National Assembly and the motivated and constitutional and inconsistent with the constitutional principles. Clause 145 and 50 of the Constitution. He maintained that impeachment to promote accountability and good governance and not a tool for settling political disputes or managing political differences. The quality of public participation process and the fairness of the proceedings. The substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 4. Mr. Otieno stated that exercise was hurried, inadequate, both quantitatively and qualitatively. Sovereign will of the electorate, given that only about 223,000 persons participated. This Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation was biased because it only contained the allegations against His Excellency Gachagua, thereby portraying him to the public as guilt before he had been asked. Additionally stated that the Speaker, Deputy Speaker, and members of National Assembly failed to accord His Excellency Gachagua a fair hearing and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of or commission of crimes under national or international law, the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing. To the following prayers: A declaration, B, and is hereby issue that the organized and conducted by the first respondent did not meet the requirements of the Constitution quantitatively and qualitatively. B, that the first respondent violated seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4. C, a declaration be and is hereby issued that the first respondent violated under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration of the first respondent to impeach the seventh respondent was invalid and the respondent shall bear the cost of the petition. Likewise, the 54th petitioner submissions nor filed physical highlighting of the submissions. Next is and 56 petitioners case. Stephen Mbugua Gituha jointly filed the petition dated 20th of October together with the supporting affidavit sworn by Wambugu Wanjohi. They were public interest litigants and defenders of constitutionality and procedural propriety of the impeachment proceedings and as Deputy President of the Republic of Kenya, as well as the subsequent nomination to His Excellency Kindiki as the Deputy President nominee. Ended that the impeachment process before both the National Assembly and the Senate is bias, denial of fair hearing, and constitutional conduct. The National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the Constitution and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to the public to facilitate informed participation. At the Senate proceedings contending that the Senate violated His Excellency Gachagua's right impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing his illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias passion of Governor James Orengo, senior counsel in the Senate proceedings, stating that they are of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of Parliament were characterized by constitutional violations and disregard for due process. The petitioners also challenged the support of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural process and was therefore null and void. They sought the following prayers: a declaration that the grounds of impeachment laid in the 24th of September 2024 did not meet the constitutional impeachment of a deputy president, that a declaration patient exercise conducted on the 4th and 5th of October was constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated conducted by the Senate was tainted by substantive and procedural, constitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and moved through an impugned process. F, the National Assembly and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, and subsequent approval of Professor Kithure Kindiki as Deputy President as it stems from an unconstitutional process and is procedural Constitution. H, a mandatory injunction directing the National Assembly and the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the impeachment proceedings violated the principles and constituted a conflict of interest that compromised. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. Did not find any written submissions, and they also did not. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on the of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest of Kenya. The petition challenged the constitutionality of the impeachment of Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy. He stated that the impeachment proceedings before the National Assembly and Senate violated 148, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby from meaningful participation. He further alleged that the exercise was marred by inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. Of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the fallen ill and was unable to continue participating in the proceedings, the Senate to vote on the impeachment charges in his absence. Mr. Gekonge stated that Article 145 of the Constitution rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to violation of the Constitution, gross misconduct, and serious reasons to believe that crimes under national law. Mr. Gekonge also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki timelines under Article 149 contemplated meaningful public before approval of a deputy president nominee. He contended that His Excellency Kindiki remained a state officer serving as cabinet secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold participation as envisaged under Article 10 of the Constitution. Process on the 5th of October 2024 was unconstitutional and in violation of the freedom of religion under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first constitutional and did not meet the requirements set under Article Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150. F, a declaration that the nomination of Abraham Kithure Kindiki is unconstitutional, null and void, and in contravention of the Constitution. G, a declaration that the approval of the nomination of Abraham by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that Deputy President by the National Assembly under Article 149 of the Constitution must constituency. I, a declaration that the approval by the National Assembly is unconstitutional as Abraham Kithure state officer. J, a declaration that the independent that IEBC at the time of nomination of Abraham Kithure Kindiki was not properly of Abraham Kithure Kindiki under Article 137(1) of the Constitution. IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament. Constitution. L, any other orders as Mr. Gekonge likewise did not file any submissions. In respect of the 50th, the 50, that is John Njomo, Clarence Eboso, their petitions were withdrawn from the consultation 11th November 2024, 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the process met the constitutional threshold for meaningful public participation and Articles 1 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural consistently with the doctrine of separation of powers, and lastly, where the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10 and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to pass and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate, and directly affected the sovereign will of the people. It was their understanding that the process had to be both quantitative to meet of citizens had to be reached and accorded an opportunity to participate, and had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of National Assembly and the adequate to reach a substantial portion of the Kenyan population, particularly citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without relying on vernacular radio stations, and those who depended on for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru ASK Show, and Tomorrow College, thereby drastically limiting accessibility and diluting representation. The Senate did not take adequate steps to ensure that sufficient were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms, citizens forums, structured mechanisms for receiving memoranda from and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. In the impeachment proceedings conducted by the Senate, by the Speaker of the Senate, and Gachagua was denied an opportunity to appear and be heard and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate present, but subsequently fell ill. He was then rushed to hospital. His legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate, His Excellency Gachagua misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of the that the proceedings of the removal from office of the deputy president before the Senate involved the reception of evidence, evaluation of contested facts, affected the fundamental rights of His Excellency. Those procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, without affording His Excellency those rights, Kituo cha Sheria contended that declining an adjournment request when His Excellency constituting a medical emergency was inhumane, and they further averred that the one-day public It was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding conducted set a dangerous precedent by constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty to adopt a purposive and progressive approach that advanced good governance, constitutionalism. They further averred that the determination of the petition on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonable and meaningful opportunity, considering the nature and the impact of that the removal of a deputy president from office was not an ordinary procedural matter, but a constitutional event with profound democratic implications. That Article 118 had to be read together with the Constitution, and that sovereign power belonged to the people. Exercise that power in a delegated capacity. When Parliament moved from office a deputy president who was directly elected by the people, sure that the people themselves were accorded a meaningful opportunity to be heard. That in such a context, not condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement. Article 1B of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as the abuse impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate many. Such a short time could not reasonably ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and utilized several well-established participatory mechanisms, including ICT platforms for structured public input, county public notice boards, and accessible announcement, town hall meetings, engagement through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single avenues, single level presentation, and transformed public hearings into mass contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. The process of this gravity required decentralized, not on the rigid and non-deliberative format of engagement. The National Assembly employed a highly structured and restrictive mode. Read out the charges, provided a general explanation of the processes. Attendees were given limited time to offer their views, and those views were recorded in a pre-designed compilation. That format did not permit cross-examination of claims and did not facilitate informed or factual basis of the impeachment. It was submitted that public participation was merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue. This reduced public participation to checkbox voting, institutional engagement. They acknowledged in their submissions that the but reasonableness. However, reasonableness is a matter that required the Speaker of the National Assembly and the National Assembly to have actively mobilized public convergence points such as churches, mosques, temples, vernacular broadcasting stations, and other accessible civil forums. The failure to which the reach of the notice and consequently diminished participation been conducted on an extremely short notice, centralized into two venues, and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagement, all of which demonstrated a failure to meet constitutional standards and called into question the validity of the impeachment of His Excellency Gachagua. It was further President from office was not merely an internal matter of Parliament, but a matter affecting the democratic will of the electorate, the integrity, ability of the Republic of Kenya, and the sovereignty of the people, and that had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Admitted that even where Parliament acted within its constitutional mandate, that received and evaluated evidence and reached determinations adverse to rights, it was obliged to meet minimum content on procedural fairness. All the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, adverse finding, to a grave sanction in the form of removal from office, and that Articles 47 and 50 of 2015 therefore applied with full force. Impeachment of a political debate, but a structured constitutional trial with legal standards, reputational, civil, and democratic consequences, which made the rights to be present, to examined, all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and has scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Maxwell, in which the court confirmed right and fair trial ought not to be unduly impeded, and that a trial body circumspect in purporting to limit and take away such crucial rights, since Article 25C there was never to be a fair hearing. It was further submitted that while impeachment was sui of adversarial testing of allegations applied, His Excellency Gachagua fell ill, was admitted for urgent medical, sought an adjournment which was refused. The Senate proceeded in received and assessed evidence and removed him from office, thereby extinguishing his ability to be present, to be and to participate meaningfully. It was submitted that a fair procession, including adjournment, where good cause was shown and no prejudice will be suffered, that could not be compensated by way of cost or by way of time. Kituo cha Sheria relies on Security Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been against him. A fair opportunity to answer and the opportunity to that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, infirm. They argued that the right to be heard to participate, not a mere formality, and included the right to attend and to answer the case, right to correct and contradict the allegations made against one. Was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective denial of a reasonable adjournment, a right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if the hearing, or if after due notice, his notice was submitted that that absence was explained as a medical emergency and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate is impugned. I submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where received and weighed, cross-examination was then crucial, the denial of which hollowed out fairness and tainted the decision. It was submitted that the expedition cannibalized fairness, and that Articles 10, 47, and 50 accommodation, especially where a short adjournment would have cured the medical emergency. Kituo cha Sheria submitted that courts had emphasized respect and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been instituted where constitutional requirements were breached, relying on the Mwangaza case. The court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the further reliance called the Court of Appeals statement that the process of removal of County Assembly, wherein it was initiated, and the Senate, that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution. And they submitted that the question before the court was not how the Senate it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied or interpreted any law or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not by the National Assembly and the Senate debate, or to substitute their that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2020 unfair, unconstitutional, and ultra vires. A declaration that the body violated Articles 47 and 50 of the Constitution by denying examination and adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit for the Senate in strict conformity with constitutional and statutory fair presence, representation, examination, disclosure, and such other orders as the court made deem fit to vindicate the lawful, rational, and fair impeachment process. By urging the Constitution that the Constitution erected precisely because impeachment was a constitutional earthquake. A short adjournment, despite His Excellency Gachagua's hospitalization, delivered the ultimate sanction without the presence of examination. The process failed the constitutional test. It was submitted that this court applied politics, but to enforce procedure, and in so doing, to the rule of law, constitutionality, accountability, and we'll now proceed to responses and submissions petitions. We'll start with the second and the seventh. The National Assembly and the clerk to the National Assembly were the second respondent in the considered petitions. They jointly responded to the petitions through a replying affidavit sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. Impeachment process was entirely constitutional, lawful, and procedural fair. Taken all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the leaders, as well and the court directives. The President followed Article 150, Sub-Article 2 of the Constitution, applies Articles 144 and 145 of the Constitution, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. He confirmed that the motion met the required legal form, at least 117 MPs, or 1/3 of all, inclusive and compliant with court orders as the national in all three national dailies on the 2nd, 3rd. Public hearings were held on the 4th of October 2024. That public and the post hand delivery, a dedicated template in English, and they were also able to visit the constituency officers. The respondents contended that 3rd of October 2024, they extended public participation to the 5th of October 2025, and that a public participation report was published. And not illusory, that public participation was not part of the President defense, as it was meant to gather general public view, and that holding it the integrity and the independence of public input, preventing it from the Deputy President's defense. Or respondents maintained that the Deputy President still received his full right. 8th of October 2024, where he appeared in person with his legal team. Petitioners, Honorable Jane Jerry Maina, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. They ably learned that the closure was directed by the women vehemently opposed to the impeachment. The respondents averred that she, from her own actions that obstructed the public. But the respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote and 282 members voted in support of the impeachment and 44 voted required 2/3 majority under Article 145(2) of the Constitution. October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate. The respondents denied any doing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the learned counsel, Mr. Eric Gumbo, and Honorable Gitonga Murugara. They identify the following issues for this court's determination. This court's jurisdiction to hear and determine the constituted petitions relating to B, whether the sub judice rule under 103 of the National Assembly and the Senate standing orders bars on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid proceedings conducted before the Senate. E, constitutionally subverted the sovereign will of the electorate expressed contrary to Articles 1, 2, and 38 of the Constitution. F, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and Excellency Gachagua as Deputy President was constitutional, proper, and politically necessary to uphold accountability. Defended the subsequent nomination, approval, and appointment of Honorable Kindiki is fully compliant with the Constitution. Their positions remain that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power their elected members under Article 1, that the Constitution mandates and bicameral supermajority representation both houses, making the impeachment framework rigorous, and analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard on the High Court's jurisdiction under Article 165. Impeachment proceedings, they submitted that such power is only residual and that impeachment is a political process and should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual the cases in Wambora and Sonko. They asserted that the courts must matters where the Constitution grants Parliament discretion. Learned Counsel also Philippines in Re Sarah Duterte, which that courts will not encroach on co-equal branches on political questions. It was their further submission that National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection, cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines and days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliament. Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation as was case. It was their further submission that public participation was adequate as the National Assembly issued newspapers, news website, and social media on the second. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order and 223,083 citizens submitted views, which they stated were engagement. Further, that the public views template was provided. Were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others, 2 others, held that timelines must be considered when assessing public participation. Excellency Gachagua's response was not required to the circulated was not required to be circulated simultaneously to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were that isolated incidents do not vitiate an entire process. They also was submitted in Parliament and recorded in the Hansard, which is a valid. The impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these thresholds set in the Wambora's case of being serious, substantial, weighty, with clear nexus, and the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that as he received prior notice of the charges, he filed his written response and appeared in person with counsel, and he was given 2 hours to assembly, and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 Parliament, as Articles 97 and 98 on the composition of Parliament have been fully principle under Article 81B. It was submitted that this was an aspirational provision to be achieved precedent to Parliament's validity, and that Article 261 provides a mechanism for addressing advice from the Chief Justice or action by the President. He contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations the Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. The Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, subarticle and hear such charges. That Article 145, subarticle 3B uses the word may, and they are discretionary and not mandatory, and the semicolon and in Article 145, subarticle 3 power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court court and Sonko case that confirmed that for governors, the Senate may be a committee, and that the same applies to the Deputy President. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the procedures under Article 124, subarticle 1, and the 10-day deadline was a reasonable exercise of procedural autonomy. Admitted that impeachment must be concluded without undue delay, and the time and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as he was cross-examined at the National Assembly, and he cross-examined National Assembly, filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment, and this was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday 19th within the constitutional time frame, but this motion failed on a vote. The National Assembly and the clerk in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocated as both parties were accorded equal time. The National Assembly submitted could not call all its witnesses due to time of expedition and not bias. They further submitted that the Senate to conduct public participation, which under Articles 10 and 118 applies primarily to legislative Senate, that the Senate, when hearing impeachment, not a legislative one, and that public participation occurs at the National Assembly, the Senate at the trial stage. Council submitted that comparative practice in South Africa, US, in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory. As the Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish. Petitioners have not pointed to any specific or omission, act or omission, showing a real possibility of bias. This is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participants Orengo and Honorable Amolo, as counsel, did not invalidate the proceedings in that Article 77(1) restricts inherently incompatible with state office, and that representing a party in proceedings is not such an employment. That any alleged illegality would affect the validity of the impeachment process, and that no actual bias or procedural shown. They further submitted that the Senate applied the correct standard proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko. The Senate found 5 charges substantiated: attacks on judicial independence, ethnic conduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court a merit review of the Senate findings. Counsel reiterated that impeachment does not, as it is not an affront to democracy, but that the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and with distinct accountability mechanisms. Counsel gave comparative analysis, resignations while President Nixon remained and Brazil's President Rousseff's impeachment while assumed office when they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 with necessary modifications, and that this acknowledges that distinct offices are not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7), as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Council